All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup today for December 9th of 2024. Brad, go ahead. Take us
And a little
away.
late start because I'm having some computer technical difficulties, but let's start in the town of Ramapo. Now, just full disclosure, I am very well familiar with this issue. I will tell you why. It is a bigger issue than everybody would realize. But starting with this, we have a first responder who's probably a member of the Hasidic, the ultra-Orthodox community, or very Orthodox, based on what I personally know about this. I'm not involved in any way, except how I'll explain in a minute, which again is extremely interesting. In any event, so in the town of Ramapo, which is Rockland County, New York, that's kind of on the eastern section, Hudson Valley area of New York, they have a very, very large Hasidic community. Let me give you the background for this story. And the Hasidic community, unfortunately or fortunately, believes that they are not receiving good fire protection. And they believe that because they're some of them think they're targeted, which I don't think is true, but they just don't believe they're getting the right fire protection. So they have tried all sorts of things, including calling me, to start their own private fire company, which in New York State, you cannot have a private fire company. They have to be connected or created by a municipality in some way. But I have gotten many concerns or many calls saying, hey, we want to start our own fire department. How do we do it? And I said, well, you got to get a hold of a village, a town, a city, or a county to bring you in. What happened here is just a sign of their frustration. I'm not validating or not validating it in any way. Just they are, it's fact, frustrated. And the ultra Orthodox have run into homes with fires and tried to put out with a fire extinguisher. And they've tried to create their own fire brigades. And in some cases, there's a belief that they are delaying the call to 911 so that they can get in there first. So with that background, here's what happens. Now you'll understand the background, the frustration of that community. In this area, there's a 26-year-old who is not part of the fire department. And he, at a fire, went up and grabbed equipment, attempted to grab equipment off the fire truck. He approached the Muncie Fire Department, which I think is New Jersey. It could be No, it could be Rockland. It is Rockland. There's a fire department right across. They're right on the New Jersey border, which creates some problems with different rules. In any event, the Muncie Fire Department, he grabs the supply line, tries to attach it to a hydrant, open the hydrant, all right, clearly interfering maybe with good intentions and out of frustration. Nonetheless, he's now charged by the police with interfering with the scene. And the Rockland County fire coordinators and the county executive all issue a statement. And the statement is, they support those who choose to be firefighters, but they can't encourage people to take their own action and start, kind of bastardizing or taking stuff off the fire truck. And so they understand that, this can't happen. So he says, we acknowledge the supervisor, town supervisor, and the Ramapo Police Department for working diligently on these issues and making an arrest, showing this is not going to be tolerated. And this is going to be one of many future stories. This is going to get very interesting. They are going to find a lawyer, because you can always find a lawyer, right? They're going to find a lawyer who tries to create their own fire department. They're going to, this community is not going to stop with this attempt. I don't think this does it. I think this arrest will exacerbate things, but keep watching.
Well,
Keep watching.
Brad, why wouldn't they just join and I'm assuming it's the Muncie Fire Department. Why wouldn't they just join that and like work within them, whether it's as a separate unit or like something why wouldn't they just do that?
Because the ultra Orthodox and the Orthodox have long beards and facial hair, and they cannot be interior firefighters, obviously,
Yeah.
right? Under
Yeah.
1910-134, that
Yeah.
can't be interior firefighters with a beard.
Okay.
So that's the problem. And they've tried joining. It's not for lack of other efforts. I'm sympathetic with them, but I'm not, right? I'm sympathetic, but I'm not. And part of the problem is in this community, they are all Medicaid. They are hundreds, if not thousands of homes. They don't pay taxes. So there's a lot of frustration against them.
Why don't they pay taxes?
Because every house is a temple. Now, for the listeners, so I don't come out sounding anti-Semitic. I'm Jewish, right? These are not anti-Semitic comments. I'm probably one of the only people who can make them and hopefully not get in trouble. But although the ultra-Orthodox don't consider me Jewish, but nonetheless, they don't. But nonetheless, the community is frustrated. They think it's personal, but the hundreds or thousands of homes, and these are massive communities. Curious Joel, there's massive communities of hundreds, if not thousands, of homes that don't pay taxes because they get them all as temples. And I don't. Nobody fights them. It's highway robbery, in my personal opinion. They're destroying the tax base. And then at the same time, they're not paying property taxes. They also take Medicaid. And then there's more frustration. I'm just explaining everybody's frustration on both sides of this. And both sides know that each other is frustrated and are upset. And so everyone thinks it's personal. Yeah. But I don't believe for a second that any firefighter, volunteer, or career would withhold fire protection or delay fire protection. That's not what's happening. They just, the community believes it's personal.
Wow.
So this is not the last of it. You're going to see way more. This is just a sign of the frustration.
Right. You and I have talked also about the EMS challenges as well, and the fact that there are some EMS agencies that are providing, and that's, to me, that's different. I separate EMS from fire when it comes to this issue.
Very different. There's Hot Sola and other agencies. Hot Sola is probably other than the nurses, probably one of the most powerful lobbying entities in the state of New York. So they have overcome a lot of legal challenges to the way they provide services because they can get anything they want in New York. It's really true. So Hot Sola, a very good organization, but they are, they use volunteers, and there's a reason that they have worked well because they've gotten State Department of Health approval to be providing ambulance services and first response services. And they do, and they address a need, right? The Orthodox community does not want non-married men touching non-married women, and that's a very strong belief. And so there are exceptions when there's a medical emergency, but they've solved that issue on the ambulance side, but they've been able to do so because you can have private ambulance services as well as municipal. On the fire side, there's no private ambulance service. Now, their true solution is go to the state. They can get anything passed they want. They probably could get approval for this. And if I was their lawyer, that's what I would be trying, but I don't believe in it, so I'm not going to do it. So I've turned down that work, not as any, feeling towards the community, one side or the other. I just think all fire departments should be municipal and connected with the municipality. And we should not have private fire departments because it will be the Old West, right? Yeah. It'll be bad. So, but keep watching. This is going to keep happening.
Okay.
So, okay. Want to go to Kansas City?
Yeah.
Boy. Today's fun because there's a lot of really short things that have some fun conversation behind it. So the suits aren't complicated that you've posted. It allows us to do some, cool talk. So we're back in Kansas City. It's like we never leave. Kansas City is like the new LA, isn't it? I mean, they seem to have a lot of issues. In any event, they've now settled for a total of 1.5 million, but for this one is 850,000 as a part of that 1.5. They've settled reverse discrimination suits. And this to me is an affirmative action thing, right? Obviously, this all goes on the Supreme Court case, right? With our friends from Connecticut, New Haven. And this is a reverse discrimination case. There was a 2022 promotion of a black captain to deputy chief. And the three individuals who brought this are white battalion chiefs who believe they were wrongfully passed over on account of their race. And so they accepted the 850. This is a tough topic, right? So what's more interesting is these three suits followed the rise of Donna Lake, Fire Chief Donna Lake, to lead the organization because there was a mandate to address discrimination, right? Which was the increase the hiring and promotion of women and Black. Which, by the way, I want to talk about Black and African American in a second. I just learned something. In any event, but there was a comment, Chief Lake, again, female, said the days of the fire department being ran by older white men are over. That's not a bad statement. It's a little hard, but it's not a bad statement if you're trying to gender and race equalize, at least to the community, your fire department. But
it's identity, though. Again, I think the goal should be that these things at some point become irrelevant. Race and age and, these things should be irrelevant. Gender, they should be irrelevant. But to get there, we've got to go through a period where they are consciously taken into account.
So based on that, why? Because I'm having a hard time wrapping myself around this. Why they would settle? I get it. It is reverse discrimination. It's affirmative action, right? And
right.
But affirmative action, look, go to Syracuse, go to Boston, go to the other. We just saw someone else had a consent decree, and maybe that's what's missing. Maybe they need a consent decree from a court pursuant to a Department of Labor challenge that says you need to equalize the leadership. But flip this.
I tried to find the complaints, and I was not able to find them. They were filed in state court. The state court does not have an online access portal to look at the complaints. So I think understanding the complaints may help us understand why the settlement occurred. For example, if there is a civil service system that regulates how promotions are supposed to be done, and you have people who are in queue to become promoted through statutory civil service or by ordinance or charter civil service, and they are bypassed. Whereas something that's obvious, but where the promotion of deputy chief would be discretionary, I think it becomes I get to your point there where it really becomes, what's the grounds for them to object to the way it was promoted? Just because you think you're better, just because you have more experience. So I don't know. If I had access to the complaints, I think we might understand it. I think one of the interesting points here was, why did 2 battalion chiefs go for $350 and one went for $850? And the article actually discussed that, and they said that the 2 battalion chiefs who that would be Chief Little and Chief McDaniel, who got the $350, they're still on the job, so they still have the opportunity to move up. And when I guess they looked at the damages, they said, okay, you could still retire as a deputy chief. So we're going to take that into account. Whereas Chief McGrath had already retired. And so his opportunity to increase his pension had already gone by. And therefore the settlement had to take that into account. So that was the difference there. But, I think that the Kansas City Star went back and looked at some other cases, and they're asking questions not unlike the questions that we see in many other places. Why so many lawsuits? Why so many settlements? This is the taxpayers' money. Are we not properly managing the organization? And these are a symptom of a bigger problem within the organization.
Yeah, but here's the thing, right? So let's assume that it is a symptom. And look, again, there are only 8% of the last stat I saw, 8% of the career departments are women. Right. So naturally, there's going to be, right, more men raising up over time, and women are newer. So they don't have that 20, 15, 30-year history in the department. But if you know the lawsuit, right? The lawsuit on the other side was, I'm a female or I'm Black, I can't get promoted. There's no Black, fire chiefs. That's always the beginning of every lawsuit we see. The minority says there's no minorities in the position I wanted. And so they paint the picture that you've got a policy of discrimination, an unwritten Monell type policy of discrimination, right? Meaning there's no written policy, but it's kind of the unwritten policy. This is how you correct it. Now, I'm not saying I don't sympathize with everybody who's qualified, right? But all things being equal, if everybody's just as qualified, and which is not how affirmative action necessarily works, but if all things were equal and everyone was just justly qualified, same qualified, why can't you choose, black over white or woman over male or
Well, and
whatever?
that
How's
gets
the
back to
remedy
my,
this?
yeah, that gets, and I agree, but that gets back to whether or not there's a structure in place that you're deviating from. And I think that's really the root of it. And when you have the head of the department making statements that essentially strip everything else away, we're going to go after older white people. We don't think older white men should be running fire departments, and we're going to take care of business. You couple that with this decision, and I think it's an easier case to make. Now, I agree with you, and I know when I was in law school back in the 80s, there was an open question about whether only courts could develop race-conscious remedies. And that there was actually, some decisions that talked about that. Finally, the Supreme Court said, no, if the employer and the community reach an agreement, then they can engage in affirmative action. So it doesn't have to be under a consent decree or under some sort of a court order. But that was an open question back in the 80s when I was in law school. That was
When affirmative action came out, right? I mean, that
right.
was it, mid
Right.
80s.
Well, and again, there was a question about whether or not race discrimination prohibited any consideration of race, or whether or not you could use race-conscious remedies. And I think, again, I go back to what I said before, that at some point, we got to get to the point where race is irrelevant, gender is irrelevant. It's like the color of your eyes, the color of your skin, color of your eyes, color of your hair. The color of your skin, your gender should be irrelevant. But I guess to get to that point, and I'm not sure how many decades more have to go on before we get to that point, because I know even when I was getting out of college, there were seats. I was applying to medical school. There were seats that were reserved for women and African Americans that I was not eligible for. This was back in the 70s. This was in the 1970s. So we're talking about 50 years of this. And so I think we're still struggling with it, struggling with the implementation of it. And the Bakke decision, I don't know if you remember studying the Bakke decision, that was on med school and basically put the kibosh on doing that they said that you cannot hold seats for certain genders or races. So, but med schools were still at the time doing that. So again, my point being that we've got from the 70s, so we've got 50 years of this.
Right.
And at some point, you think we've got to get to a race neutral or a race irrelevant, gender irrelevant point.
And I think when you say race neutral, that's the problem with the former chief's statement, right?
Yeah.
The statement was, again, the days of the fire department being ran by older white men are over. Now, that is per se discriminatory. If she inserted one word, solely, if it said the days of the fire department being run solely by older white men, would have been a different issue. But I think she announced a policy and she made the promotions. I didn't say that. I shouldn't have said that. She's the one who made the promotion. So she had I don't even think it's an unwritten policy. I think it's a blatant policy statement.
That's a very brilliant approach to this. And I'm assuming this was an unrecorded comment. And I wonder if the attorneys might have argued that because it's unrecorded. Maybe she did say solely.
Right.
Or at least that was her intent. And that changes the whole complexion of it. Absolutely. Yeah.
So anyway, that's what we got. And I'm not an expert on affirmative action. I will say this, though. I had a friend, black friend, at Tulane. He was number 2 or 3 in our class. He was a brilliant orator. He was on my moot court team with him. Him and I won the national championships of moot court. I'm a champion. But and the judges, look, I was good, but the judges just commented on him constantly saying, you could sing us to sleep with your voice. And these were federal court judges sitting, right? But he said to me, he then gets accepted at one of the biggest firms in the nation. Now, he was, again, number 2 or 3 in our class, right? He was brilliant. And just so everyone knows, in law school, there are no names on your blue book on your final exams. So they don't know who they're grading.
Just the number, right?
Yeah, just a number, right? So it's not race or favoritism based. And so I talked to him about a year after he's at this great, huge firm. And I said, Charles, what's going on? How was it? How is it? And he goes, it's horrible. I said, why? He goes, no one thinks I belong. Everyone thinks I'm here on affirmative action. He's like, I work my butt off
Yeah.
for decades. He said, I've got all the accolades in the world. He said, and it doesn't matter. Everyone thinks I'm here merely because I'm black. They think
Yeah.
and maybe he checked the box for the African American, the black, right? But he said, he said, I hate it. I said, so you're not a fan of affirmative action? He goes, I never have been. He said, let the qualified be qualified, let everyone else fall in line. And I thought that almost a statement. I thought it was a great statement, but it does affect you negatively when you're
Oh, yeah.
qualified. And think of it in the fire department. You know darn well we're going to say, oh, you're not qualified. You're not qualified. We're going to beat people up if they jump in line. The fire department, the fire service is orderly. We like line. We like rank. We like order. We like,
we need it.
right?
We're not like, we need it. We need it because, right, because when, somebody's going to give an order and somebody's going to follow the order, there can't be debate, there can't be questions about it. There's not enough time. You've got to get the roof, you get the roof, get a line to the second floor, get a line to the second floor. We're not going to debate it.
Right. And we're not going to say, oh, are you only giving that order because you're something Jewish, black, female, whatever, right? Anyway. So the only last thing I'd like to say is because one of my clients called me the other day, and I want to share this. This has nothing to do with anything except on this. I've always been so careful to say African American and not black. Or brown, or right. Jesse Jackson was always like the black, the brown. And so my friend of mine, a client of mine who calls me, and he's in a fire department in Long Island that's almost predominantly black. And he was at a conference and I kept saying African American. He said, I want to tell you something. You kind of insulted me at your conference. I'm like, why? I've been so good to say African American. Like what? He's like, I'm not African American. He said, I'm European. He's like, so you're trying to be PC. He said, but it's offensive. He said, just say black. I said, wait a minute, but I say black and it's offensive to some. He goes, it shouldn't be. So I'm just throwing that out there because no matter how hard we try sometimes, right? And he wasn't mad. He was trying to be helpful. So I'm sharing his help, which is, black is okay to say, or brown, or, but there's some words like that we don't say certainly anymore, but we've come so far, we need to go backwards. No. Okay. Do you want to pick up the FDNY FLSA suit? This is great.
Yeah, this one is it wasn't the line firefighters here, but it was the inspectors, fire inspectors, and there were a number of different areas of concern. I'm not sure what the total amount would have been. I think they discuss it in there. But
4.3 is a big sum of, right? It's a big
but you've got several hundred plaintiffs, and I don't think it came out to all that much for each individual.
No, it was 70%. You're saying it's about 70% of what it would have been, so it would have been about 6 million or so.
Yeah, about 6 million, and so. But again, typical types of FLSA issues. One is that they work through their meal period, and that's a very common issue. We in the fire service, we tend not to punch the clock, which I think is a good thing. I often get calls from fire chiefs, and they've been the chief for a number of years, and a new HR manager or a new finance person comes in from private industry and says, what do you mean you don't have a punch clock? You got to get a punch clock. We don't need to, okay? We basically have a schedule, and you're assumed to work certain hours. When you're not on the line, when you're in a administrative position such as fire inspector, the employer can dock the half hour or an hour, whatever it is that you have for a lunch break. They don't have to pay you for your lunch break. So, but sometimes you get so busy that you work through lunch, and it's just the way it is. There needs to be a reasonable procedure to follow in terms of getting that 30 minutes or whatever it would be the meal period compensated for. And you can't make people jump through crazy hoops. You've got to make it easy. So again, this was one of the issues that they alleged, that they were routinely apparently working through meal periods and not getting compensated for it. There was 45 minutes a day that on average they were not being paid. They were basically working and not being paid. The other big issue here would be what's called their regular rate was not being properly calculated. And I apologize if you can hear my dog barking.
That's why we have live shows. I have the
I
printer in my
believe
background.
FedEx. I believe FedEx has arrived, so he's letting us know that FedEx is here. So,
Good dog.
but basically, regular rate is one of the most common alleged FLSA violations today, not historically, but certainly today. And it has to do with, particularly in the fire service, where we have a lot of add-ons such as longevity pay, medic pay, hazmat pay, you name it.
Seniority.
And
Right.
all of those things, when it comes to overtime, all of those what we call wage augments have to be factored into the person's regular rate for overtime purposes, and very often it's not. So they're alleging a violation there. Another, I wouldn't say common, but we are seeing it more frequently, especially over the last couple of years, is failure to pay overtime in a timely manner. Sometimes the overtime doesn't get paid for a couple of pay cycles after the time it's worked. And, if that happens once or twice, it's not a big deal. But when it happens over a long period of time, that's a problem. Let's see.
I thought the most
things.
interesting one, and not that it's new, right? This doesn't shock you or I at all, but the working outside the shift before and after. When I was chief, it was so hard because people are like, "Oh, I'm just finishing up chores." No, you're done. Go home. It's over. And, they're like, "Well, but the laundry's still in the machine." I like, then leave it because I'm not paying you overtime. And then I had to realize, me, a lot of other people will email at 2 a.m. or whatever time. And I used to get upset when people didn't respond to me at some point. I'd be like, "Hey, Joe, why didn't you send me back anything?" And I realized, wait a minute, I'm requiring them to work outside of hours. So I stopped doing that.
Uh-oh. Brad, it looks like you just froze up. I don't know if you can hear me, but all right, until we get Brad back, I think what happened, Brad has got a new computer, and we had a couple of glitches before he was able to log on. That's one of the reasons why we started a little bit late, and I'm not sure if he's going to rejoin us or not. We'll give him a minute. He may have to log off and then log back on, but yeah, okay. So we'll wrap up that FLSA case and we'll move on to the next one. Okay. And the next case is out of, oh, and he just logged off. So hopefully he'll log back on. The next case is it's actually the culmination of a series of cases. And here comes hopefully Brad logging back in.
I'm sitting in a construction zone where my
All
internet
right.
is going in and out.
Okay, we got you. We got your sound. I don't see you. I don't see your video yet.
We'll get it at some point.
Okay.
I'm sure I'll come back somewhere.
Okay, well, we kind of moved off of the FLSA case out of New York, and
Yes.
we're into Illinois, which I think is a pretty interesting case. But we had a female. She was described kind of both as a firefighter and as a lieutenant, and I think there was some question about when the incident happened, she might have been a firefighter, but at some point, at any rate, she's a lieutenant. There was some sort of an altercation that happened when she was at a structure fire with a particular lieutenant, and they went apparently hands-on, and she originally filed a suit in federal court and alleging violation of her Fourth Amendment rights, which would be a seizure because he literally grabbed her and pushed her up against the wall, and gender discrimination and a number of other state law counts. The district court dismissed her federal claims and opted not to take the pendant jurisdiction over the state law claims. So then, and that case was upheld by the Seventh Circuit. And Brad, you and I talked about that case. I don't know if you recall it, but we talked about it. I think it was either last year or the year before. And so we've got a link there to that case. And she then files suit in state court on the state law claims, but apparently there was a statute of limitations issue that she was running into. And the Gender Violence Act as written, was not specific to municipalities. It was sort of a general act intended to deal with gender violence. And that had I believe, a 7-year statute of, 7-year statute of limitations. So when they filed the suit in state court, they alleged primarily violations of the Gender Violence Act. The city wisely said, hold on, not so fast. We have a Tort Claims Act that says that you've got to bring claims against municipalities within a year. And the plaintiff said, no, the 7-year applied. So basically the court said, no, the law that applies here is going to be the Tort Claims Act, which is basically 1 year. And she had 1 year from the date that the U.S. District Court, the federal court, had relinquished jurisdiction over the state law claims. And I think she went like 18 months or 14 months. She basically missed that window. And the Court of Appeals agreed. Yeah. So this never got to the merits of the case about whether or not she had been assaulted, whether or not she had her civil rights or the Gender Violence Act was actually violated. It was basically a procedural issue that, she didn't bring the case in a timely manner.
And you wonder, there are remedies. I always hate saying this, but if she had a lawyer and the lawyer didn't file on time, she's got a remedy against the lawyer. Malpractice.
Well, we hate to talk about that, right? We hate to suggest
we do, but because we never want to be the targets of it. But right, or it's the opposite. And you don't know. We don't know who's error or fault or whatever it was. But it's obviously kind of a slam dunk case. Do we know? Did the person get arrested and convicted?
I don't see some discipline. Yeah, there was some discipline. I have that in my database that I looked over. There was some discipline. I'm not sure that I don't believe he was charged criminally.
Okay.
But one of the things, now this was new to me, and I don't do federal court practice, so I'm not familiar with all the ins and outs of federal court. But the fact that the key date was the date the trial court relinquished the state law claims. And I think their mistake may have been what mine would have been, was that those claims are still valid as long as it's being appealed. And because they went to the Seventh Circuit, and she was certainly within the 12 months of when the Seventh Circuit made the decision, but she was outside the window for the state law claims. So I think that I think is pretty understandable from an attorney's perspective. Again, I think the folks that practice strictly in federal court, that's a real advanced issue. They would realize that those pending claims, the statute runs as soon as those pending claims are decided.
Yeah. And my background, I guess I viewed this differently because I worked for the New York State Court of Claims for 2 years, and that's where you sue the state. And the only court in New York, you have to sue in a specific state. So we saw this all the time where somebody sued federal and they're like, oh, I want to come back to state court. I was in the wrong court. Attorney error, that's unfortunate, but you can ask the court to extend the time to grant leave. That's what should have happened here if it was even possible. But I guess I wasn't surprised because I've seen this occur in New York a lot. But the problem with attorneys is some attorneys think they can do anything. And I have people ask me all the time, do you do this type of work? Do you do that type of work? And I say, this I do, this I won't do, or you need to go to federal court. I don't want to practice in federal court, although it's much easier. It's more routine than state court, which is like the Wild West. But it's, it's clients never know. Clients assume the lawyer they go, a lawyer's a lawyer, but you don't go to a foot doctor for your brain.
Right.
It's the same thing. But the problem is in many states like New York, and I'm sure many others, you're not allowed to say you specialize in anything. Right? We could say we focus. We can't say we specialize.
Concentrate. I say concentrate. We concentrate.
Concentrate, right? Or a substantial portion of practice is centered around, right? But we can't say we specialize because at least in New York, there's only one specialty, which is a patent lawyer, which is a bar you take. But so how are the clients supposed to know? I can say I do anything, and the client doesn't know. And I'm not saying it's the lawyer's fault here. I'm just suggesting that maybe if it was the lawyer's fault, maybe the lawyer didn't do this. If you haven't sued municipalities before, you shouldn't start figuring it out on your first case. There are way too many pleading and notice requirements and time requirements where you could just really mess it up. I'm not blaming this attorney. But for any of our would-be future, clients out there who go to an attorney, you better, you need to ask questions. Have you done this type of suit before? What was the result? We don't, TV commercials try to educate non-lawyers that they may have their rights, right? And as much as I hate lawyer TV commercials, that is what they do. That came from Morris Bart in New Orleans, who was the head of the first pioneer into lawyer advertising. But lawyer advertising does educate people. On the other hand, it just educates you to go to a lawyer. It doesn't educate people as to, I'm a foot doctor, not a brain doctor, right? Look, I don't do workers' comp. Don't ask me a comp question. There are people who do just comp, but I could just tell somebody, oh yeah, I do comp all the time. How are they going to know? So anyway, this is a kind of a caveat emptor issue where, beware of your lawyer, not so much. Okay, well, let's wrap up on your most interesting. I love that this is last. This is the greatest. This is our kind of the keynote, right? The capstone of today. And you raise a great question. Let's expound on it. This is a whole great 30-minute, hour-long topic. Don't worry, we won't do that. But you raise a question. What should happen to a firefighter after being convicted of a criminal offense? And then you continue. When the conviction's overturned. Well, let's go to the beginning, because I'm curious how you handle this. So start at the arrest. You have a client who's arrested for, who cares, right? I've got one who's convicted of arrested for arson now down in Long Island. I've got one who's been arrested for stealing in central New York. I've got a client, right? I've got all sorts of arrested people. So let's start at the arrest and I'll ping pong. So Curt, my statement when somebody's arrested is one of two things. One is if we can prove it on our own, we are allowed to pursue, right, that we are allowed to pursue that as against the, right, we can charge them. Look, if I have a video of you stealing, I can use that video against you. Or what I normally do is I put somebody on a non-punitive administrative leave, right? You're on a leave. If you're determined to be innocent at some point, that'll be the question for this, we will back pay you. And that's risky for the department, right? Because if the person settles or it gets adjourned in contemplation of dismissal where, okay, be good for 6 months, we'll dismiss it. The charges are dismissed and now you got to pay back pay for all the time. So let me ask Curt, what do you do at the arrest? Because we'll get to the end of this, but let's start at the beginning.
Yeah, I think you're right there. I think there's a couple of questions that you're going to have to ask, and some of it is going to be: is there a collective bargaining agreement? Is there a civil service regulation of suspensions? Can you suspend them? Can you put them on administrative leave? Does the leave or the suspension have to be with pay, without pay, and so on? So I think there's a broad range. There's not going to be a single answer to that. You've got to look at some of the local issues that are going to be prevalent there. But the point you made, a really good point, is one that we've got to emphasize, is that initial suspension is not a disciplinary suspension. It's a suspension because we've got allegations and we can't have someone with these allegations pending in the workplace. Okay, it's not healthy for you. It's certainly not healthy for the organization, the people that are going to work with you, and also the ultimate customers. So we've got to get them out of the workplace. Now, whether or not they're going to be entitled to retroactivity on that, again, is a function of the laws, the collective bargaining agreements, and so on. I would say there's no inherent obligation to pay all that. And again, sometimes I think it's hard sometimes for firefighters to kind of wrap their head around that until they put themselves in the position of being someone's employer. So if you have a firefighter who hires someone, let's say you hire someone to work around your house, or you hire a babysitter, or your daycare, or whatever it may be, and for some reason you need to not have them work for a while something gets sorted out, are you actually going to feel obligated to pay them? And then I think
Right.
when you look at it that way, then you kind of get a better perspective on things when you look at it that way. But at any rate, I don't think there's an inherent obligation. I think it's the right thing to do, and especially for firefighters. And I think it's going to be an obligation in most places where there is collective bargaining and where there is some sort of a civil service process.
Now let's get to step two.
Mm-hmm.
Step two is they're convicted. But
Mhm.
remember, not finally convicted, they're convicted. So what do we do at the conviction, which is pending appeal? They're convicted. Do you fire them or do you continue all of this? And to me, if there's still an appeal chance, and this case that we now have out of Jamaica, not Jamaica, Queens, New York, like actually the country of
Jamaica, the island of Jamaica.
Yeah. But here, right, we have a situation where the appeal is successful, overturns the conviction. So what do you do now that the person, right? And so to me, when somebody's convicted, I do wait to see if they're appealing it. And if they're appealing, I normally, because of this, I agree with this, I normally say, hold in place, you're not fired. You're still, right, suspended, pending, or on a non-punitive administrative leave, pending the results of the appeal. But this could go on for 4 years.
Yeah, but let's go back now, because something that you had mentioned before is that when someone is arrested, if we can prove that they did something wrong, we can fire them right from the get-go. We don't have to wait until, the problem becomes the police and the prosecutors are not going to want you to use their witnesses. And particularly where, I use a case in my discipline class where there was a 15-year-old girl who was brought to a firehouse by a 50-something-year-old man, and they had sex in at the firehouse. Okay. Now, and then he subsequently was charged with statutory rape. Okay. So in addition to sexual misconduct, it was statutory rape because she was underage. And there is no way the police and prosecutors are going to allow the fire department investigators to interview that she's a victim. She's a sexual assault victim. So you're not going to be able to investigate. Therefore, you're not going to be able to discipline the firefighter. Unless he admits it and opts to resign, you're not going to be able to prove your case. So inevitably, you're going to have to wait until the criminal trial is over. Now, once the criminal trial is over, then you could conceivably hold a hearing. You bring the witness in, you bring all the witnesses in, and then the firefighter is terminated. Then it doesn't really matter if there's an appeal or not. Even if it's overturned on appeal, you've already proven the case there. But if you don't do that and you say, oh, you're convicted, therefore you're fired, without proving it, now you open yourself up to this appeal problem.
Right. And there's one more issue, which is the burden of proof for a criminal case is beyond a reasonable doubt.
That's right.
That is not the burden in administrative hearings, unless the CBA says otherwise, which I haven't seen one that does that yet. But nonetheless, the burden's different. So it is conceivable that we could prove preponderance of the evidence, which means more than 50% of the evidence weighs in our favor, or it could be a lower burden, which it is an administrative hearing, substantial evidence, which means there's just some evidence.
We don't want to go that way.
No, we don't. But that's the world I live in with administrative hearings. And then you get all the way to beyond a reasonable doubt. So which is it? And so you could, the defendant could win at the court and say, hey, they didn't prove beyond a reasonable doubt, but we could all just have preponderance, a much lower standard, and still prove you're guilty. So is that fair? Look, the employment setting is not sending you to jail. So we can have the same thing. I had one lawyer said, send the people, your jury, basically, send them in to watch the trial. And the trial's then presented, right? And they can then say, okay, we watched the whole trial and you had your day in court. We're just going to say, based on what was presented, we're finding you guilty.
I don't think that. I don't think that's the way to do it. But I will tell you one thing. I'll give you another way that it could be done, and I think it's kind of a dirty trick kind of way to do it. But when the member is convicted and sentenced and has to serve excuse me, has to serve time in prison, you basically put him back to work. Okay. And then when he doesn't show up, you terminate him for job abandonment.
Right.
I
And
think
I've done that. I've done that on multiple occasions where at the arrest stage, they're being held without bail, which doesn't happen a lot in New York, but where they're being held without bail. And I say, you know what? They have failed to show. I got one more. I have one where they were waiting a trial or waiting an appeal. They were facilitated. They were put in a facility outside in a prison, right? Outside the fire district. In New York State, for volunteers anyway, you have to live in a certain area. So since they changed their residency, I got them on your residency is no longer right where we're staying.
How do you give them a hearing? You got to give them a hearing. What do you go to the jail and give them a hearing?
No, you don't. So for a change of residency, it's automatic termination of volunteer membership.
How do you prove it? How do you prove it without giving them a right to contest it?
Well, we found out where he was. Yeah. And, and here's the worst thing. Wait, here's the funny thing. So, and this is the games we play as lawyers, but not the game. So in New York State, you have and many other states, but you have 4 months to challenge administrative decisions, right? Now, if you're unconscious or in a coma, it stayed, but not necessarily because you're in prison. So you only have 4 months to do that, right? To challenge it, but you're in prison. And so the time expires and now you've blown the statute of limitations. So I have said to clients, they're going to be in prison. What do you think the chance is they're going to get a lawyer to challenge you being dismissed from the fire service, right? And even on the career side, unions don't want to deal with it. They did it. It's embarrassing. We're not going to waste our limited amount of union funds. So there's all sorts of things to play out. This is the reason I said this could be a great hour-long lecture, right? And for those must-have policies, we just about hit about 1,000 subscribers, not signed up, 1,000 subscribed viewers to our must-have policies page. But I wish it was 1,000 for us. And so if must-have policies, we will have a policy that addresses, if it's not already addressed in the CBA, we will give you an alternate policy to consider about what happens when somebody's arrested. But, basic things, just to sum up what Curt and I have said, right? If there's an arrest, you still can try to prove the crime. You're not going to want to interfere, and the police don't want to interfere with their sentencing, and you should take into consideration the gravity. So here's the thing. If this is a petty larceny that we can't prove on our own because we don't have video and nobody will give it to us, most likely they're going to be reinstated, right? But and the charges are going to be dropped because it's petty larceny and they're going to be given a traffic ticket, effectively a violation. And so what are you going to do with that if you can't prove it? Yet we now have somebody who stole something, who's going to be in the fire department, who's going to be in someone's houses. So you've got a lot of challenges. This is a great topic we should address at a conference, but we'll definitely do it by policy.
And I think one of the things that folks have got to understand is when you're the chief, you've got all these issues. You've got your budget, you've got politics, you got this firefighter doing this, you got the union, you got all these things that you've got to think about. And then you have something like this happen. And it's easy to lose track of it, okay? This firefighter only has one thing to think about. And they're going to hold you to doing it right. So when it comes to discipline, we've got to do it right. Even though we've got all these other things, even though we've got all these other distractions that are sort of burdening us. And I think, the lesson here is in Jamaica, they had one of the chiefs either retired or passed away, but the one that was responsible for tracking this, but it fell through the cracks. And, it looks to me like once he was convicted, and that was the sort of the end of the trial, they just terminated him. They didn't go through the extra step and give him a hearing and then terminated him. And I think if they had done that, they wouldn't have had to deal with what they're dealing with now.
Probably true.
So,
and just to end this, I'll end it on something you said before. People in the back have no idea how hard it is and all the BS you deal with in the front office. These decisions are very difficult. They take a lot, very tough.
Even I didn't realize it until I went in the front office. It's hard for a firefighter to understand exactly what goes on at headquarters in a fire department. You think you do, but you don't.
You don't. Oh. All right, everybody.
All right, man.
That's it.
All right. Hopefully everybody's hard at work on their holiday shopping. I've got about half of mine done, and Brad, how about you? Any? No? Yeah.
No, I'm getting there. Amazon is loving me, I'm sure, though.
Yeah. Yeah. Well, that's what FedEx was just here. So,
Yep.
all righty. Well, that's going to do it for another edition of Fire Law Roundup. We'll see everyone next week.